Now, new details have emerged about the strategy that Donald Trump's legal team is using to prevent an interview with special counsel Robert Mueller. The New York Times has obtained a confidential letter Trump's lawyers sent to Mueller in January relating to the probe into Russian meddling in the 2016 election. Well, the 20-page memo claims Mueller's office clearly lacks the requisite need to personally interview the president, arguing the information the special counsel seeks is practically available from another source. It also warns President Trump could, if he wished, terminate the inquiry or even exercise his power to pardon if he so desired. Well, let's bring in Peter Mathews. He's a professor of political science at Cypress College in California. He joins us live from Los Angeles. Peter, so the lawyers for President Trump have said in this letter that Trump won't be interviewed, that he could end Mueller's investigation and use his executive powers to pardon if he wants to. Can Trump actually legally do this?
I guess in the end, the Supreme Court will decide that, but it sounds to be quite outlandish that they would claim this, because the president is not above the law. He's also under the law like any other citizen, and that's a bedrock principle of the United States of America, the rule of law principle, put forth by John Locke, the great British philosopher, that says that the law should apply evenly and equally to everyone, regardless of whether you're rich or poor. So this president thinks that he's the president, he's rich, he's above the law, and that cannot stand. So the courts, I don't think, will allow that to stand. And other presidents have been actually had articles of impeachment based on the obstruction of justice. For example, Bill Clinton did, and he was actually impeached. Richard Nixon the articles were voted upon, including obstruction of justice, and that time he resigned right away instead. So it's happened before that the president can be called to testify, as Clinton did actually, and we'll have to see what happens if the courts get the case and if he refuses to comply with the subpoena, if that act comes up.
Yeah, and if Trump refuses to be interviewed, Robert Mueller will then have to decide whether to push ahead with possibly an historic grand jury subpoena. But can the President of the United States actually be subpoenaed?
You know, that has never been settled yet, because when Bill Clinton was threatened with a subpoena, he decided to comply with an interview anyway instead of going through with a subpoena. He went and said, I'll go ahead and interview with you to the special counsel. And he'd had an interview by closed-circuit television, but he was live interviewed. And in that case, there's a precedent there where Trump could actually interview, not necessarily right there in person, but live on a closed-circuit system. And that would be more like it. But I don't know. It's never been settled as to whether the president can actually be subpoenaed or not, whether that threat can be carried out fully.
You talk about the Clinton case. Are there any similarities between this case and President Clinton, who fired his FBI director in 1993 when the FBI opened those multiple investigations implicating the Clintons, but there were no investigations into whether Clinton's use of constitutional power was actually an obstruction of justice?
The FBI director, by the way, was William Sessions, not Jeff Sessions, with different Sessions, and that man was also himself under, I guess there was some charges with him on corruption, and so Clinton fired him on that basis, not because he was investigating him. So in the case of Clinton, yes, there is something similar. If you look at whether the President Clinton tried to get people to lie on his behalf to obstruct justice with a criminal intent, that's the key. The key question is there a criminal intent? And that's why Mueller wants to interview the President, to ascertain whether there's criminal intent behind his obstruction of justice charges or possible charges, because what happened was the President decided to fire FBI Director Comey, and he also publicly admitted that he was doing it because of the Russia investigation. Now, that's such a close circumstantial case of obstruction of justice that many people are saying there's enough evidence here to go ahead and start the impeachment proceedings. But a criminal proceeding is different than an impeachment proceeding. Impeachment is political. It's up to the United States House to impeach him by a majority vote, whereas the question of whether or not a president can be tried while he's in office on a criminal case, that's a different question altogether. But Mueller should continue his investigation, in my view, without any kind of interference by the president, because the rule of law principle calls for that. The president should stop interfering, stop trying to intimidate, and his lawyers sending letters like this to Mueller. That's completely out of bounds, in my view, because this country is a system of checks and balances between the different branches of government, including the courts, and the FBI and the Justice Department is supposed to be somewhat independent from the president in terms of a criminal investigation or possibly an investigation on impeachment charges.
Peter Mathews,
there should be some separation there.
Thank you for talking to Al Jazeera. Now, an ISIL-linked group in the southern